The Go First saga has opened a Pandora's box for the Indian aviation sector. Days after Go First was first granted bankruptcy protection, preventing lessors from repossessing the aircraft, a global aviation leasing watchdog has put India on a watch list with a negative outlook. Aviation Working Group, also called AWG as an acronym, says that Indian aviation player has failed to comply with international aircraft repossession norms. Remember, on 10th of May, the NCLT admitted Go First's plea for involuntary or rather voluntary insolvency, blaming engine maker Pratt Whitney for faulty engines and its financial troubles. NCLT granted Go First protection under a moratorium period for preventing lessors and lenders from recovering from Go First for a period of up until the moratorium ends. Remember, lessors then approached the National Company Law Appellate Tribunal, NCLAT, and the ruling is expected today. On the show, what is AWG and its issues with NCLT order? Why are lessors miffed with Go First? And what do these developments mean for flyers in India in general? Joining me at this point in time in the studio is my colleague Santikari. Also joining us is Ravi Kini, who is the managing partner at law firm MV Kini. I want to come to you first, Shomalo. A lot is happening in the aviation space, primarily on the back of Go First saga. Let's start from the very beginning. What exactly is happening at Go First and why are lessors miffed?
Lessors are miffed because, Shweta, as we see, Go First is now kind of facing bankruptcy proceedings, and the ball has now shifted into a court where both the parties are mudslinging, have indulged in mudslinging, and the Go First has blamed it squarely on the engine makers and the manufacturers, while AWG, which is a body of lessors and plane manufacturers, they are saying that it's India, I mean the NCLT ruling, it is going against the international norms that are in place, and which is a Cape Town Convention, which is a global treaty aimed at increasing financing and leasing of aircraft makers. And India obviously is a signatory to that convention, but it has not been ratified by the parliament, which means the country's NCLT laws, they will have primacy over whatever concerns are there, and they'll take the required decisions to move ahead with the process.
Okay, so it looks like it's going to be a long drawn process at this point in time, with AWG coming into foray.
Right, absolutely. I mean, that narrative is now shifting to India versus the rest of the world in that case, and it's going to be a bit of a blow to the image of India's aviation hub aspirations, because at one time when you're saying the sector is primed for growth, these incidents, they somehow put you in a position where the lessors, and in this case in the aviation industry, they are a very important component because they finance your plane purchases, and they are an important cog in the wheel. So the sooner this gets resolved, the better for the entire aviation sector.
Okay, let's get to the crux of the problem, and I want to come to you at this point in time, Mr. Kini. The lessors are saying that we were hoping to repossess our aircrafts as soon as Go First ceased operations, before it went to NCLT, before it declared insolvency, at a point where they were unable to get payments for what was agreed upon, and the fact that lessors had to then approach NCLAT because the NCLT order does not allow them to repossess aircraft is a blow for them and for the entire lessor industry at large, which where there's a lot of faith involved beside what is legal and on the paper. Lessors are now currently, and 3 of them are currently in NCLAT challenging the NCLT order. We don't know what's going to come in from there. But as far as AWG and AWG's comments on India is concerned, that we do not have enough faith, and this is sort of jolted our faith in the Indian aviation space. How do you read these developments?
I think AWG is absolutely right, because what is happening here is that I'm assuming that these are operational leases. These are not finance leases. So if these are operational leases, then the asset belongs to the lessor. And NCLT, even if you go by the moratorium, what is prescribed, there is no automatic moratorium for assets which are not of the company. So therefore the concern that NCLT has gone beyond what it is required to do, and assets which belong to, and there is a international obligation which is by way of Cape Town Convention that India has ratified, and so therefore there is clearly a problem here, and if we do not get our act right, after Kingfisher, the same fiasco did happen in Kingfisher. And after that, I think Indian lessees found it very difficult to get aircraft leased. And so therefore, this is a problem, and I think we should get it sorted at the earliest. I don't think there is a case for holding somebody else's asset, especially when that asset is brought into the country in terms of a particular treaty. The Cape Town Convention. So
but correct me legally if I'm wrong, and I think legally India's indigenous laws, and in this case insolvency laws, take precedence over and above what we signed as a part of Cape Town Convention. And in which case here NCLT has firmly said if a certain organization is under moratorium, then essentially their assets need to be protected so as to protect them from going bankrupt.
That is where the question is whether it is their assets. It is not their asset.
Okay.
That is the crux of it. The asset is not of Go. The asset is of the lessor. So it is not, if it's a finance lease, I can understand the asset would be in their books. But if it is not their asset, then how do you prevent them from taking their asset, which is brought as per a treaty? So there is a treaty. They are giving their asset, relying upon that treaty. They are believing that India signs a treaty, they will honor it. Now, if you don't, now then there is a problem, because NCLT, whatever when we talk about NCLT orders, moratoriums, they talk about the assets of that company. You cannot, but if it is somebody else's asset,
and not of assets in possession of the company, I understand there is a difference there. Assets that belong to a company, but assets that are currently in possession of the company.
But then the assets which are in the possession of the company, there is an IDERA which is signed as per the Cape Town Convention, given to DGCA, which is very, very clearly states that in case there is a default, that they can take the aircraft without the lessee's permission. So when there is a treaty which is signed, which is ratified by India, there is a IDERA which is filed before the DGCA. There is no provision, according to me, wherein if there is a case, if there is an arbitration, all that moratorium happens. But if there is an asset which is not yours, which is brought into the country by way of a particular agreement, right? And then you do not honor that agreement, that I think is a little bit of an issue.
Okay. Okay, important points raised there by Mr. Kini, and I want to bring you in, Soumalya, at this point in time. The statements that have come from Aviation Working Group are a dampener because it questions the faith that lessors have in the Indian aviation sector as a whole in various airlines. What sort of large-term impact are we looking at?
Yes, you're right. And as Ravi pointed out, after the Kingfisher fiasco and the Jet, obviously Jet is still in the bankruptcy courts proceedings, and this is going to be a body blow for a sector which is looking to get fresh wings and fresh impetus after undergoing after debilitating impact from the COVID pandemic, and these incidents are going to have an impact on the various bankruptcy or the various recovery model processes that we are seeing or witnessing in courts right now. Anyway, we all know that the sector is known for turning cash piles into loss-making concerns. So if the country or the regulators behave in a way where the lessors, which are a global body, and it's an interconnected world in a sector like aviation, you cannot really throw them to the dogs. So in this case, they have to tread carefully, and that is why there are reports coming in that the Indian Parliament will soon pass the law so that to assuage the concerns of the lessors who are rightfully concerned about their business operations in the country.
Okay, I understood that, but the Wadia Group, and even after AWG's statement has now come on record, and in fact before that also came on record, squarely blaming Pratt Whitney. And I want to bring you in, Mr. Kini, here. They said that they were profitable, they held about about 7.8% of the market share. They were minting money. They had enough passengers, inflow of passengers, incoming of flyers. So what happened, therefore, happened in a period of approximately 4 to 6 weeks, right before they declared insolvency, did not have enough operational money. In which case, how do you then blame them for not, for perhaps not realizing that such a problem may arise? Obviously, the right course of action for a company that does not have enough operational money is to knock on the doors of NCLT, which is what they did.
No, see, look, if there is a contract between parties, right, and if you are not paying as per the contract, there are rights and remedies available to that party. One of the remedies available to the lessor is to repossess, right? Now, if you say I will use other means to stop repossession, according to me, this is not fair in any context, because first of all, it is misusing the NCLT process, according to me.
Can I at this point in time, I want to understand, are you saying that the NCLT, or you do not agree with the NCLT ruling?
Yes.
Okay, please go ahead.
Yes. So what I believe is that, one, the NCLT also has to see it in the light of, first, that it is not their asset. So there is no obligation to protect, the asset of the company. It is asset. The obligation on the NCLT is to protect the assets of the company. This is not the asset of the company. The second point is, if, let us say, they have to also, it's not just a domestic issue here. It is the asset is an asset which is brought into the country because of a treaty, which is India's international obligation. Mm-hmm.
But sir, let me also take you back to before India became a signatory of the Cape Town Convention, and right before that, every time an Indian airline was, finding itself in tight waters, the lessors would take back the aircraft, further dwindling away, and just taking away any sort of options that the airline may have to revive itself. And if that were to be the case here, Go First would have gone under long back.
But that is exactly the thing. How can, it is a decision of the lessor. It is their money, it is their risk, it is their call. I cannot say that I am not paying you the lease rentals and I will still want to hold the aircraft. Now that by any standard will not work, and that by rule of law it should not work, right? So I don't think that we can say that now might is right. I have the aircraft, so I will not let it go. I will not pay you rent. I am defaulting on that. There is no doubt that they are defaulting on the rent payments.
And so what protection do airlines have at a point where they're not making money, or they don't have enough money in their kitty to run their operations, and lessors repossess the aircraft? They are literally left with no, absolutely no jet to take to skies, and that is the end of them.
No, see, it is again.
What protection? I want to understand legally, sir. What protection do airlines have?
No, you can't say that a bank, can you say tomorrow that I will not pay my housing loan and they cannot repossess my house?
No, but I can definitely ask my landowner to give me some time, which is what has happened in this case.
But that is exactly that. You are assuming that they have not given. The question is, there are a lot of, during COVID, and there are other airlines, right, in the market. During COVID, do you think they
I'll give you COVID's example. If I were not to be able to pay my rent during COVID, I would try and negotiate with my landowner and ask for some time, which is what moratorium does. It gives time to an airline player to recoup, recover money, get its operations back in order, and then pay the lessors.
Did court give you that relief, or your landlord gave you that relief? That is the question.
In this case, the court gave the relief.
No, in your case, it is the landlord who gave the relief.
That is correct. In this case, the court gave the relief.
Or it is the obligation. It is up to the landlord. It is up to the lessor to give you that credit. And they have. If you go and see other airlines, right? There are many airlines in the market. Most of them have defaulted during COVID. Most of them, the lessors have worked with them. And in many cases, aviation is not a very simple business. It's always there are ups and downs, and the lessors do work with. They also understand that if they repossess, it's not easy for them to deploy the aircrafts somewhere else. They are multi-million-dollar assets, right? They will if they can't do this, if they cannot deploy, they are still in losses.
Okay.
And getting money from NCLT for operational creditors is zero chance.
Right.
If Go Air goes down, the lease rental defaults which the lessors will have to face, and there is no way they are going to get it. That's for sure. So they had to work. Instead of going and declaring, they should have, and they should have tried to negotiate with the lessors and try to come at a middle ground. I think that, and most lessors, that at least with my experience that I have, I always am on the other side of the lessors. They do negotiate. They do sit with you, and they are reasonable. So if they have faith in the airline,
the expectation of reasonability is also very it's with you, sir. It lies with you. It's not imposed to everyone and anyone out there. So your expectation of reasonability, and we don't have a representation from Go First at this point in time, but I assume they were also expecting Pratt and Whitney to be reasonable, but that did not really happen. So it's very subjective. The expectation of reasonability is very subjective. In this case, you may expect the lessors to be reasonable, but in the past, they haven't been reasonable. And as I mentioned, I'm going to take you back to 2008 before signing off the Cape Town Convention. Every time an airline reported problems with its books, every time they suspected that an airline will not be able to pay back, they took the possession of aircrafts back, leaving airlines high and dry. In this case, if this were to happen with Go First, it would have already gone under.
But that is their legal right.
Okay.
They have that billions and billions of dollars they invest in the asset. So that's their legal right. So if tomorrow you start investing in a house, and then the lessee decides, I will not go for whatever reason, maybe he's out of a job, maybe whatever reason, that doesn't work.
Okay. I want to bring in Shweta at this point in time. Shweta, we were discussing AWG's downgrading of India. Currently, they've scored us 3.5. They are going to score us a 3 because of the recent instances with Go First and how that sort of has affected the trust that lessors have in the Indian aviation players in general, and that will have a long-term repercussion. And we were discussing the long-term repercussion on the airlines. What about repercussions on flyers? What can they expect? Because at the end of the day, I think beyond corporate sufferings and corporates making money, not making money, it's the people who continue to suffer.
Yeah, absolutely. And Shweta, unfortunately, it's going to be a bummer for flyers because it will result in higher yields for the airlines, and they'll have to pay a higher amount on the rentals, because if the lessors, obviously they realize that it's a scenario where they're not going to recover the cost in the long run, then they'll have to increase the rates, and obviously it is going to translate into higher ticket prices for the flyers at the end of the day. And in a way, they are one of the most important stakeholders in any industry, but unfortunately the way the past decade has been for the sector in general, they have had to bear the brunt, and with last moment cancellations and airlines going under, resulting in skyrocketing fares. So in this situation also, I'm afraid that... Do you think
this is going to have an impact on the airfares? If yes, how?
Not immediately, but yeah, in the long run there might be a case where the fares may increase because the airline operators will have to pay more.
Okay, airline operators will have to pay more, and they may pass that cost to the flyers. At this point in time, flyers are already struggling in absence of many choices.
Yes, the lesser the number of airlines operating in the country, the lesser choices they have, and obviously the fares will also be higher in that scenario.
Fares will also be higher, and that will have a long-term impact on not just players here in the aviation sector, but also flyers in general. With that, I think we're going to end this discussion. Mr. Kini, Soumalya, thanks very much for joining